The broadcast is now starting. All attendees are in listen-only mode.
A very good afternoon to one and all, and thank you for joining us today for today's webinar. The topic for today's discussion is voluntary winding up of companies under the new Insolvency and Bankruptcy Code 2016. As we all know, that the Insolvency and Bankruptcy Code has been introduced with the objective to consolidate and amend the laws relating to reorganization and insolvency resolution of corporate persons, amongst other things. One of the prominent features of the code is the process of voluntary winding up a company. The code has consolidated the process of voluntary winding up into a single section and has simplified it so that it is easy to follow. Our speaker for today is Ajay Abad. Ajay is an Indian CPA and company secretary by qualification and has more than 10 years of experience in the field of mergers and acquisition, corporate restructuring, winding up and closure of companies, regulatory advisory, and India entry and exit strategy. He has supported a number of international as well as domestic companies operating at different stage of their life cycle to close down their operations in India. He is also a qualified insolvency professional leading the winding up practice at SKP. Welcome, Ajay. We're happy to host you for the webinar and for all our listeners. Please note that all our listeners are in listen-only mode. If you have any questions, please share them with us through the question box on the right-hand side of your screen, and we will address your queries at the end of the webinar. Now, without any further delay, we'll start the webinar. Ajay, over to you.
Thank you, Pratik, for the introduction. Hello, everyone. Very good afternoon. So to start, without wasting so much time, we will just initiate the discussion on this voluntary winding up topic. So this topic is interesting because nowadays everybody is talking about the setting up of businesses in India. A lot of foreign investment is coming into India, but we are talking about the closure of business in India. So I will just give you a brief to start with this topic of voluntary winding up, which basically deals with the closure of solvent companies. Let me just give you a quick background of an opposite topic, that is starting of companies in India. So I'm taking this topic because it's also important to understand that why so many companies have been incorporated during last couple of years. So first and foremost important reason is that India is attracting a lot of foreign investment, and it stood at position of 9th in attracting the FDI globally, which resulted into a lot of incorporation, and a lot of other multinational companies are focusing on India because of its requirements. Second is there is a lot of need of infrastructure in India, so infrastructure companies is also coming to India for the various reasons, and they are collaborating with the Indian companies for developing the infrastructure in India. Apart from that, Government of India is quite active in their initiative of Make in India and promoting the businesses for India. Last 20-30 years, India has been serving globally the IT requirements of the entire world, and it is one of the important destination for outsourcing the IT and ITES services. Further, there are a lot of Government of India has also given a lot of export related incentives, which also helped companies to set up their manufacturing facilities in India and export the manufactured material from India. So all these reasons have overall lead to a situation that in the last 20-30 years, and we don't forget that there is also a startup economy which has started 5-7 years back, and pursuant to that also a lot of companies has started incorporating in India. So this has piled up a lot of incorporation during the last 20-30 years, and now this entire thing has come out, and not every business is successful in India. So now that why there is a need of this closure of businesses in India. In one hand, Government of India is promoting the easy and faster processes for the incorporation. On the second hand, it also want to close. They also promote to close down the entities which are not operational. So, what are the reasons of getting non-operational companies, and why there is so much non-operational companies in India? So you might be knowing, or you're reading in the newspapers, that because IT is one of the main factor for the Indian export industry, but due to the automation in the industry and the shifting of a lot of businesses, or the IT outsourcing to the other developing nations. Now when there was an IT boom, the other back-end offices, BPOs, KPOs has been incorporated. But now due to this machine learning or artificial intelligence, a lot of work has been reduced, and which lead to there is no requirement of this non-operational companies. Not to forget that there are a lot of startup has been started their business, but out of 100 startup, only few are surviving and would be in a position to handle the financial and the financial stress. So because of this, the company need to close down, and further apart from that, there is also tax reforms is happening, like GST has implemented just now, but because of that, a lot of companies has been redundant, because earlier years the company has been incorporated to cater or to meet the requirement to be within this below tax rates. But now with GST, there is very small entry point, or the levy point. That's why there is a lot of companies are now, the businesses cannot operate through the multiple entities. So this lead to the situation that now the management is thinking on the ground that they need to close down the entities. These are the overall story for the non-operational companies. Again, the non-operational companies has also a lot of fund has been stuck in the non-operational companies. There are few projects has been started, or a lot of projects has been started in the past, and now the project has over. Now the companies need to wind down. Few companies started and they not able to kick off their business, or they decided at a global level, or they decided not to start that businesses. And the last one is that one of the important reason is that now the management is with the introduction of 2013 Companies Act, there is a lot of penal consequences on the directors in case they fail to comply with their or fail to perform their duties. And this leads to a situation that now everybody wants to, if the company is non-operational, non-performing well, and they are not in a position to maintain them, then these days are thinking of closure of these companies. So now that a lot of companies have setting up, now a lot of companies also simultaneously coming for the closure. So let's discuss these two options, which we basically dealing with the solvent closure of the solvent companies. First and important option is the voluntary winding up, which is regulated currently under the Insolvency and Bankruptcy Code, which is recently introduced in India in 2016. and the provisions of the voluntary winding up has been notified and has been effective from 1st April 2017. And the other option is the fast track exit, which is popularly known as fast track exit. But if you go to the law, it is called as, under the Companies Act, is a removal of name from the register of company, or deregistration process, deregistration of the companies from the Indian company. So I'm not going to discuss fast track exit in detail, but I will just touch upon only the few important aspects in the end of my presentation. So taking this this introduction, I will just start the briefing you about the voluntary winding up. When I'm in my presentation, I will use different connotation frequently. So I just want to clarify that if I'm using the corporate person, it means the company which is in the voluntary winding up process. If I'm using the FTE process, it is to be referred as the fast track exit or the removal of the name from the register of company. So these are the few connotation which I will use it frequently. So so now when we touch upon this voluntary winding up, so I'll just give you a quick snapshot of what is the important aspect, or what are the key factor of this voluntary winding up process. So first and foremost important factor is that it's a time-bound process. The legislation of the code, the 2016 code, has been prescribed specifically prescribed the timeline for each and every activity. We will discuss it further in the next slides. Second important aspect of this code is that it requires that only a licensed insolvency professional to be act as a liquidator in the entire process. Again, on this topic also we will discuss it more in the next slides. Third important aspect, it's a completely a privately driven process and very less involvement of government organizations. Fourth important aspect is disclosure and transparency in the liquidation process. So code seeks to bring out a lot of clarification in terms of how the process should be run by the liquidator, what needs to be done by the stakeholders and the creditors. So they have laid down the process efficiently or in a good manner, so that there is no ambiguity in while running the process or while understanding the process between the stakeholders. Then the fifth important aspect is the power and the duties of the liquidator is well defined, so that he is also clear that what is his role and responsibility while dealing with the closure process. And last, an important aspect which is very important for the management perspective, that they are still in existence, and there is no requirement that board is not available, or board is dismantled from the company. So board is in continuation, and they can also supervise, or they can work with the liquidator during this process. And whenever liquidator need any support from the management or board, they can definitely he can definitely discuss with board and take the proper decision, because the board and the management was running the company in the previous years, and they know in and out about the company. So that is one of the key factors which new framework has offered in the with the introduction of 2016 Insolvency and Bankruptcy Code. So now everybody is asking that what is the difference between the earlier, or whether what is the difference between the earlier regime or the other processes which or other methods which is generally used for the closure of companies, or whether earlier the companies or the management was not looking for closure of the entities. So my answer is for that is that the earlier also management was looking for the closure of entities for the non-operational entities. However, the earlier law or earlier regime is there is no it's not a process is not time bound. There is a lot of gap in the processes, and there is no clarity that what role needs to be played by the government authorities and the liquidator or the management. So because of that, a lot of companies have even started the process, but they stuck because there is no timeline on there is no responsibility on the government side on closure of these matters. So considering this, so we will just quickly touch upon what are the important factors which basically distinguish this new code or new process from the earlier or against the FT process, which is also another option for the closure. So first important aspect of this new code is that you can initiate the process immediately. In case the management decided to close down the entity, they can initiate the process instantly. Vis-a-vis in the fast track exit method, the object of the fast track exit method is to the option has been only given to the companies which are non-operational companies, and then when they are non-operational companies, then they can use this option as a for the closure of entity. However, in the new voluntary winding up process, there is no bar or embargo on the which entities or can go for the closure of entity. Both the operational and non-operational entities can opt for this voluntary winding up process. Second aspect, differentiating factor is licensed insolvency professional who is going to run the entire process on behalf of management or on behalf of the company. So previously in 1956 Act regime, anyone could act as a liquidator, but as per the new code, only licensed professional can act as the liquidator, which ensure speedy closure in most appropriate way. The licensed professional is expected to be equipped with the provisions of the code to complete winding up on timely manner. And this help because he is the qualified professional. He is in position to take the right decision, and also rules, regulation, and the code also enable him to close the process on the timely manner. The third important aspect which we have discussed just before that, board coexist with the liquidator. The powers of the board of directors shall not cease and continue without hampering the independence of the liquidator, which was not the case in the voluntary winding up under the 1956 Act. Then fourth important aspect, distinguishing factor, is that it's a substantially a private process. Earlier, the process, when in the earlier regime, when the process used to run, there is a provision of that first the company liquidator need to run the process, and he need to handle the affairs of the company, and he need to close down the affairs of the company in the particular manner, and he need to hand over his report or his findings to after the closing down all the aspect to the official liquidator. and the bureaucracy come into the picture at that point of time. Then official liquidator, there is no guidance available that what he will look into it, what is the timelines within which he need to close the process. So that's why he used to take his own sweet time to close down the his recommendation or his work, and then he used to hand over the his finding or report to the High Court. And High Court also, those were already burdened with a lot of cases. They also used to see it after that. So a lot of bureaucracy was involved in earlier regime. However, this new code has substantially reduced this entire channeling through the various parties, and now it's and that's why we can say that it's substantially a private process. The next point, which I already discussed and defined, that because of there is no government intervention, and the professional would take over the entire operations, and he will run the process, and he will submit his final report to the NCLT, and then NCLT will look into the finding, and if they find it everything perfect, then they will pass the resolution order. The next aspect is difference in process. The fundamental of process remains similar to erstwhile provision of under the Companies Act 1956. However, the code seeks to reduce intervention of regulatory authorities drastically. Further, unlike 1956 Act provisions, only solvent companies can file for voluntary winding up. And also, creditor approval was not required in earlier law. And however, the new code mandated there is a requirement of approval from the creditors. The next important distinguishing factor is guidance on timeline, which we will discuss it in the later slide in more detail. But here the code rules regulation try to government the regulator try to give the timelines for each and every activity, and maybe which is applicable for the shareholder, for the directors, for the liquidator. So all parties know that what they need to be done within how much period of time. Next important factor is limitation of director's liability. If we compare this with the FTE process, this is most important difference between the voluntary winding up and the FTE process. Because in the voluntary winding up, there shall not be continuation of any liability post dissolution of the company, except in cases of fraud or misrepresentation from the directors. However, in case of fast track exit mode, the liability of the directors are open-ended. That is, they continue over after the company is dissolved. Post enactment of the Indian Companies Act 2013, the penalties on account of non-compliance are stringent in nature, of which includes monetary as well as non-monetary. It means the imprisonment related penalties also include with the introduction of 2013 Act. So these are the important distinguishing factor which give the edge to the new voluntary winding up process over the other methods which were used to there, and management is not willing to go for that, and the available method, which is the fast track exit. Now let's come to the point that what I need to do now that I understand that this process is important, or the process is simplified, and there is an advantage of going with this process. So what I need to do to initiate the voluntary winding up process? So first and foremost criteria, or you can say the eligibility criteria for the initiating this process, has that company has not committed any default. Not default in the sense that they have not, they are not non-compliant or they are not in a position to pay their debt, or they have not paid any dues which are payable to their creditors or their lenders. So this is the one important eligibility criteria for going. So no default. If the company or the management believes that there is no default, or company is in position to pay all its debt, then they can immediately initiate the process of voluntary winding up. So now this is the eligibility criteria. Then when the management has decided that we are not in default, now can we start the process, and what we need to do to initiate the process? The first and important aspect here for the initiation of process is declaration of solvency from the majority of directors. What do you mean by declaration of solvency? Declaration of solvency means that company will be able to pay its debt in full from the assets of the company, or in case there is any outstanding dues, their assets is sufficient to pay all their debts. That is the first important aspect which they need to cover under the declaration. Second important aspect which they need to give in the declaration is that company is not being liquidated to defraud any person. So the objective or the intent is very clear that the company is not going to liquidate it to defraud any person. And this declaration needs to be given by the majority of directors. When I said majority of director, it means that more than 50% of director needs to be given this solvency declaration. If there are two directors, then both the directors are required to give this declaration of solvency. If there are three directors, then two can give the declaration for the solvency, and which is verified by an affidavit. There is no distinguish between that which director need to give the solvency declaration, whether it should be a foreign director, whether it should be a resident director, whether it's a nominee director, whether it's a additional director, who need to give this declaration. So there is no guidance available, or the act itself is not, code itself is not distinguishing on that front. So we are of the view that any director would be can be in a position to give the declaration of solvency. So this is the first important thing or step they need to do to initiate the process. Once the declaration is given, then the special resolution needs to be passed by the members of the company. And we will discuss the entire process in my next slide. So I'll just give you the important aspect to kickstart the process. And then the special resolution is approved. Then the next step is, if there are any creditors outstanding or they're appearing in the books of accounts, then the approval is required from 2/3 of the creditors for the voluntary winding up process. So this is the main and important aspects which will help company to initiate the voluntary winding up process. So let's discuss the overall process in detail, so that you will get the sense that how the process will work in entirety. So first we discussed that declaration is the starting point for the initiation of the voluntary winding up. After the declaration, within 4 weeks, the company will be in a position to initiate the voluntary winding up process. Once the declaration is given, then the approval is required from 2/3 of the creditors for the voluntary winding up process. From the declaration, there is a member or the shareholder need to pass the special resolution for approving the decision of the directors for the voluntary winding up. Second, they need to appoint the liquidator for running the voluntary uh, winding up process. And third aspect is to get the approval from the creditors, if there are any creditor. As we discussed, that 2/3 of the creditors' approval would be required from the for initiating the process of. So while discussing the process, I would also like to go with the timelines, so that you will also understand that how the process is how it needs to be handled in time-bound manner and in the proper way. The second, once the special resolution is passed, then there is notification needs to be given to the Register of Company and the Insolvency and Bankruptcy Board of India on commencement of voluntary winding up within 7 days of passing the special resolution. Once this intimation is given and the liquidator is appointed, liquidator need to initiate the winding up process as per the voluntary winding up rules or regulations prescribed by the Insolvency and Bankruptcy Board of India. IBBI, Insolvency and Bankruptcy Board of India, is the governing or regulating authority of the entire process. So they have issued the specific guideline or regulation for running or for operating this entire liquidation process. So once after appointment of liquidator, first thing he need to do, within 5 days from his appointment, he need to issue a public announcement for the voluntary winding up. Public announcement means the advertisement in the two newspaper. One is which is widely circulated. One is in English language, and the second is in the regional language. And the intention or the requirement of public announcement is to invite the claims from the creditors. If there are any creditors who has the objection or who has the unclaimed claim, then they need to submit their claims to the liquidator within 30 days of time. So this is the overall overall requirement, or you can say that this is the intent of the public announcement. And simultaneously, he also need to open a voluntary liquidation account or a separate bank account in which he will transfer the whatever available money is there in the company, and or he will and whatever the money will realized during the process of after the sale of available assets of the company. I am not going to discuss in detail the liquidation process itself, because it's a duty and a responsibility of the liquidator, who is a qualified professional. And then the next step would be the liquidator would wind up the affairs of the company. When I say that he would wind up the affairs of the company, it means that he will discharge all the liabilities. He will dispose of all the assets of the company and realize the whatever money is available generated out of that, and then he will distribute that money to all the stakeholders in the prescribed format. Prescribed format, I mean that there is a prescribed order has been given in which the money has been given or circulated or repaid to the stakeholders. in this regulation, IBBI also mentioned that liquidator shall endeavor to complete the process within 12 months. It shows there is a commitment from the regulator side that this process should be completed within 12 months. In case liquidator is not in a position to close this process within 12 months, then he need to call for the stakeholders meeting, and he need to justify the reason for non completing the process for completing the liquidation. So you can see it from the overall process perspective that there is a clear-cut guidelines for each and everything. There is a specific responsibility assigned to each and every involved party, and the timelines are very critical, and we believe that the results will come and it will help in closing or running the process very efficiently. And once the liquidator wind up the affairs of the company, he need to submit his final report to NCLT, and the NCLT will dissolve the company by passing the order. Bypassing the order, and from that date the company is dissolved from the register of company, and they officially dissolved from the as a legal entity from India. So we have seen this, we have understood that what is the requirement, what is the eligibility, and the overall process for the running the voluntary winding up process. Now we will just discuss what are the important aspects which one need to understand or carefully look into while going into the liquidation process or winding up process. First and important aspect is declaration of solvency by the directors. It is very important from the directors' perspective that they should inquire in the affairs of the company, or they should take the stock of the situation or understand the overall position of the company, and then only they should give the declaration of the solvency. They should consider various matters such as present and future, certain and contingent, fixed and liquidator's liability. Then, so to avoid any misrepresentation. So once they will understand the overall position or situation of the company, then they can give the declaration. It will help them to avoid, it will help them to take a conscious decision that company is solvent, company would be in a position to pay its debt, and there would not be any situation in the future that it will be treated as the misrepresentation from the director in case there is no sufficient funds, or company would not be in a position to pay its due entirely. So this is one of the important aspect which we believe which director needs to be keep in mind. Second important aspect is the repatriation of the excess or surplus fund or infusion of the shortfall of funds. When we say here the important aspect is that when the company, there is a lot of funds available in the company, it is important that if you are starting the process immediately, the control or the amount, whatever the surplus available with company, is going into the liquidation account. So directors are losing the control per se from that surplus funds, and the funds is now available for the distribution. So if the money quantum is very high, then management should take a conscious decision that when they should initiate this process. Second aspect here, regarding the shortfall. When after assessment, after the limited due diligence, if they believe that there is a during the liquidation process, the dues are more than the assets available for the company, then they should infuse the more funds in the company, so that there should not be a situation after at the end of liquidation process that there is a shortage of funds. So that's also important aspect. Third one is the planning and strategizing the cleaning up of the balance sheet. Why it is important? This is important from multiple sides. First and important side is the income tax aspect, which is required to be considered in case of write-off of liabilities. Then second aspect, from the exchange control perspective, in case you are writing off or writing back any liabilities or assets, then you may require the approval from the Reserve Bank of India. So all this planning needs to be done at this level. The third, next important aspect is the clearance from the income tax authority. As code does not require any specific approval from the income tax authorities. However, as per the Income Tax Act, there is a requirement that after receipt of notice from the liquidator, income tax office require minimum 3 months to come up with their claims. So this aspect also needs to become up. Further, the aspect in relation to the open assessment is not in there is no clarity that how income tax authorities will take up this matter. Next one is the disposal asset, that how the assets needs to be disposed and what would be the implications or the indirect tax implication on the sale of those assets. Failure to discharge all the liabilities. So the next question is that when I said that failure means that if there is more liabilities than the available assets, then what would be the consequences of the entire process? So these aspects needs to be considered before you take the decision on the liquidation of the company. So when you said that liquidator is the important, liquidator is going to play a very important role in the entire process. So we'll just quickly go through the important what it entails. The first is that he need to prepare the various report, register and books of accounts on behalf of company for his liquidation process. He need to invite, collect and verify the claims which all the stakeholders will submit. He need to prepare or form the liquidation estate account, which is the collection of the money into one bank account. Then he need to intimate the various different government authorities. He need to issue the public announcement, which we discussed in the form of advertisement. He need to engage professional in case he required their assistance in the overall liquidation process. He need to carry on the business of the company if necessary for the beneficial liquidation, because some contracts are open, and if these contracts are not fulfilled in a proper way, then there could be a lot of liabilities can come up. So these things he need to take care. Then the next important aspect is realization and sale of and distribution of the assets. Then once the liquidation process is complete, he has paid all the available money to the stakeholder. He need to get the liquidation account audited from the third party or non-interested auditor, and after that he need to apply to the NCLT in the specific application form for dissolution of the company. So this is the main role of the liquidator. It's very important aspect in overall process, and the pragmatic view, the person liquidator who is good in taking the pragmatic view or pragmatic decision would be always a preferred choice for the management. Then who all are involved? So we'll just discuss the who all are involved in during the process. So first is the National Company Law Tribunal, who is the jurisdiction authority based on the Register Office of Company. The National Company Law Tribunal will needs to be referred in this case. Currently, there are 11 NCLT benches are established in India for the various states. And what is the important role of the NCLT is to pass the final dissolution order after submission, once the liquidator submits its report. Liquidator, we have discussed his roles and responsibility. Professionals, in case there are critical matters which liquidator is not expected to do, or he is not qualified to handle those matters. In that cases, in that situation, he can take the assistance from the professional, like completing the income tax assessment, to defend the claims or defend the litigation matter in front of other bodies, and in relation to compliances and accounting as well. The valuer is required in case there is any assets which needs to be disposed of. And the other statutory authorities is the ROC, which liquidator need, or company also need to inform ROC, IBBI, the Insolvency and Bankruptcy Code, Bankruptcy Board of India, and the income tax, and the RBI in case there is a foreign investment in this thing. So when we have this is the overall flow of the process. So now there is, as we discussed, there is a specific provision available for closure of companies under the fast track exit, which is also known as removal of the name from the register of company. I'll just give you a quick overview of this process. That first, as I mentioned, this fast track exit is generally suitable for the operational companies. What is the eligibility criteria? That the company who has incorporated failed to commence its business within 1 year of incorporation, they can go for the fast track exit, because they have, in fact, they have not even started their business. And the second important eligibility criteria is that they should not, means there is no business operation in previous 2 years. So this means that company is non-operative in last 2 years, which means that any operational company cannot take the route of fast track exit for closure of their business. Again, per fast track exit is the private process. In this, the director need to give the indemnity bond, that we are in a position to pay all the dues in the of the company, and based on that, and in case there is any liability comes up in the future, we would pay those liability at that point of time. Companies should have the nil balance sheet for going for the fast track exit. It means that for repatriation or for paying the available balance to the stakeholder or the shareholders, you need to look for the other possible option, like dividend, buyback, capital reduction, or other methods to go for the fast track exit. Again, after the due process, the one need to file the application to the register of company for fast track exit, and then in this process, the director's liability would be continuing as if the company is not dissolved. That is one of the disadvantage in this fast track exit. So when we see the voluntary winding up, we believe that the proper company where there is no assessment is going on, it can be completed within 6 to 8 months. However, in the fast track exit, it can be completed within 3 to 4 months. So now that's so this is the overall process or overall background of the voluntary winding up, or the closure of the companies. So I'll just touch upon the current scenario of current facts of the voluntary winding up. For voluntary winding up, currently after it notify after on 1st of April 2017, lot of companies have started opting for the voluntary winding up. So far 85 company has been opted for the voluntary winding up, and if you go through the name of the company, very big conglomerate or a big multinational companies is also opting for this. It means that these guys are also taking the conscious decision based on the requirement of the and to avoid the liabilities of the directors. So I'll just read out the couple of prominent names which come out, like Gucci India has filed for the voluntary winding up, Daiichi Sanko, Eden Murray, HSBC Global Shared Services. So these are the quite prominent name which has been initiated the overall voluntary winding up process. So we believe that in the near future, voluntary winding up process is the key for the closure of businesses, because it is basically a private process independently driven by the liquidator with a shorter time frame. The code is running in the right direction and is in line with the global practices, removing all overall hurdles which prevailed in the older laws, due to which closure of solvent company has become a lot smoother. To conclude, the new law has removed the concept of official liquidator, shifting the onus of all activities and consequences onto the company liquidator, which is expected to improve the liquidation process. So this is what I wanted to give you the perspective, and now I am open for the any questions in case you want to discuss any questions with us.
Thank you, Ajay, for taking your time to share your valuable insights with us. There are a few questions, but due to shortage of time, I don't think we will be able to take all of them. So for now, let's take the first question. We have a question which says, what would happen in case there is a pending assessment of income tax?
Yeah, so as discussed in my during this discussion, so there is no clear-cut guidance available under the code that how the income tax department will treat assessment while dealing with the open assessment, because there is no clear-cut mandate. Even if they receive the from the liquidator, whether they would take the matters as quickly as possible or not. There is no clear-cut guidance from the income tax department as well as from the insolvency and bankruptcy code perspective. Even though the code is overriding all the applicable laws, but and currently it's in its very early stage, so there is no even the practical experiences is available in relation to this question.
Okay. We have another question from Aruna. She's asking, is there a requirement for official liquidators report to the NCLT?
There is no requirement of official liquidators report at NCLT, since the code emphasis on the professional liquidator who is qualified to run the entire process and responsible for closing and discharging all his duties and paying all the dues dues outstanding for the company. So only the not the official liquidator is required. Only the professional insolvency, the licensed professional who has passed the relevant exam is only his report required to be submitted to the NCLT, and there is no other requirement for the official liquidator report.
Okay, thank you, Aruna, for that question. I hope that answers your question. There's another one we have from Shavank. He's asking, what are the FEMA issues when there are foreign investors / FDI? What are the approvals required?
So if you see the exchange control regulation, which requires that in case there is money is repatriated during the course of as a liquidation proceedings, then approval from the or no objection certificate from the income tax department is mandatory. So this is one requirement from the exchange control perspective. Second requirement is that while sending the money, it is very important that how the company has whether the company is compliant at the time of bringing the investment in India. So like all the compliances in terms of FCGPR and intimation to the RBI, and the UN number is in place or not, that is also important while repatriation of the funds, because that shows that company is compliant and the money has come from proper channel at the time of investments. So this is only the requirement from the exchange control perspective.
Okay, we'll take one last question before winding up the webinar. One of our listeners is asking, in fast track exit, is there any maximum duration for which the director with stop has been responsible for future liability?
So it's there is no law is clear. They have not given any specific timelines for this liability. However, one can take a stand, or from the earlier regime, one can take that the liability would be continuing for around 20 years.
Okay, with that, we'll wind up our webinar. To the listeners who have asked us a few more questions, we'll reach out to you personally with answers from Ajay. I hope that they will be helpful to you. Thank you, Ajay, once again for taking your time to share your insights with us and help us gain a better perspective on the topic. We hope that the insight shared by Ajay has been useful for all our listeners. Please feel free to write to us at skpgrp.info@skpgroup.com. I repeat, skpgrp.info@skpgroup.com. If you have any questions or doubts on this topic, we will be happy to assist you with your queries. Thank you for joining us today and have a great day.